Start the recording. Okay. We're 1 minute away. We know realtors are very busy folks, so we're going to start on time. I see we got some great folks on here who I know do a lot of business and don't have a lot of free time, so thank you for joining us. Put this on Do Not Disturb. Okay. See some familiar faces. That's great. All righty. It is 10 o'clock on my calendar. I see one question already, Susan. We will be using the FAR and NABOR regular contracts and as-is contracts. I'll just tell you off the bat, there's not a whole lot of distinction except for the finance contingency between the NABOR and the FAR as-is contracts. They're both free looks, and we'll talk about that. But welcome, everybody. I am going to share my screen, starting my PowerPoint presentation here, and we are going to do a review of the NABOR and the FAR contracts, the differences. Oops. Give me 1 sec to get organized. Okay, PowerPoint, slideshow. PowerPoint slides, try that again. PowerPoint, slideshow. Okay. Here comes my screen. Can everybody see my screen? Shake your heads.
Yes.
Great.
Yes.
Awesome. All right, let me get the chat up and running. Fortunately, Zoom doesn't let you do all this we've got the chat. Okay. So before we get really started here, and a few rules of the road, you can put your questions in the chat. You can unmute yourself and shout them out. I don't mind either. It's more important to me that we get your questions answered than we hear me pontificate about the contracts. I know that you all have war stories. Let's keep those to a minimum, but ask your questions. Happy to answer them as we go along. And I will provide my contact information at the end of the program for those of you that don't have my email and cell phone. So, all right, let's dive right in. NABOR versus FAR contracts, which one should I choose? We are going to get moving along with a disclaimer. I am an attorney and I'm going to be presenting information to you, but no attorney-client privilege is going to attach. No attorney-client relationship is going to be created. And if you have any questions afterwards, you can always consult with me. If you have specific legal questions, we will address those separately. A little bit about me. My law office was founded in 2007, and we focus on real estate and business law, of course. And I am dedicated to helping small business owners, entrepreneurs, buyers, sellers, property managers. And I should add onto this slide, realtors. I spend a lot of time helping realtors get their small business off the ground. You are, of course, all small business owners in your own right, and I fully respect and appreciate that. My office has a full litigation department, and we have offices throughout Southwest Florida, but we can close across the state. A little bit about me. I've been a lawyer since 2003, which puts me, I believe, in my 18th year. Actually, 18th anniversary is coming up next month. And I focus my practice on real estate with some business transactions. The contracts that we're going to be reviewing today, I serve on the committees that draft these contracts, so I know them very well. And I'm happy to take your individual questions online and offline about the contracts. I am a recovering politician, so you have to forgive my jokes. you know, we're gonna make title great again. If you saw that joke in one of my presentations. Today, we're going to talk about the NABOR and the FAR/BAR contracts. We're going to talk about the pros and cons of each. I'm going to be comparing the main contract, that's the standard contract, not the as-is contract for most of this. The slides you're going to see will point out the differences. I will point out the similarities as we go. One thing I need to say right off the bat, I am using the newest version of the FAR/BAR. It's FAR/BAR version 6, which many of you have not seen yet because it just came out, and it's going to be published November 1st to the Form Simplicities and other forms providers. So when I talk, for example, about the finance contingency in FAR/BAR, I'm going to say a few things maybe about the appraisal that you may not be familiar with because they did make some changes, and we'll talk about that. Right off the bat, you know, I always get the question, Sam, which contract should I use? Do I need a FAR/BAR or a NABOR? And the answer is, it depends. These forms, the 80 forms that NABOR provides, the almost over 30 forms that FAR/BAR provides, these are tools of the trade. These are your tools in your toolbox to make you a better realtor and help you get deals closed. So I don't want you to ever think about which one is the best contract, because it's the best contract for the situation. You see my last bullet point on this slide, you know, who you represent and what you're trying to accomplish determines which contract you pick. So it's never a case of this is the best contract. We're always going to use NABOR as is. We're always going to use the FAR/BAR regular contract. No, you know, FAR/BAR has some interesting financing issues. There's some case law on the FAR/BAR financing provisions, but NABOR has some crazy inspection provisions. So there's different ones, and we're going to go through all those today. Let's get started. We're going to start at the very top of the contract, and we're going to go down from there. Right off the bat, on the contract, the property description. So FAR/BAR and NABOR try to be inclusive in their descriptions of what conveys with the real estate, with the real property. Things like the fact that in the FAR/BAR contract, the washer and dryer do not convey, whereas in NABOR, they specifically convey. In the FAR/BAR contract, they talk about the built-in appliances and the built-in furnishings, whereas NABOR has a comprehensive list that defines all of the property. You know, both contracts try to convey the smart home features. They do it in different ways. In the new FAR/BAR contract, they're going to add thermostats, doorbells, television wall mounts, and television mounting hardware into the contract to try and convey that smart home technology stuff that everybody's putting into their homes these days. Christy, yes, we're going to receive a PDF of the presentation. Yes, you will. Whereas in the NABOR contract, they say things like the integrated home automation, audiovisual, home entertainment, and/or sound systems, including all operational components and software. So it's very important that you understand what you're selling, and understanding this first paragraph of the contract goes a long way towards explaining to a buyer or seller what it has to convey. You've heard horror stories, I'm sure, about realtors having to buy a washer and dryer because they put it in the MLS, then somebody brought a FAR/BAR and it wasn't included. So be very careful about that. And then also note that the way you describe the property is slightly different. For example, there's no PID in the NABOR contract, but you do need to know if it's a condominium or a homeowners association, and there are parking spaces or garages or cabanas or storage lockers or boat docks. All of those things have to be laid out in the NABOR contract, whereas the FAR/BAR doesn't provide for that. Okay. Next up, this is a very important difference between these two contracts. The offer and acceptance provisions are not the same, and they determine how long your inspections are, or how, I should say, how much time you have for inspections. So under the FAR/BAR contract, it specifically says that the contract is effective as of the last date signed and delivered. Bob, the PID is the property identification number that the appraiser gets. I'm sorry, I'm reading the comments as they come in as well. So the effective date in the FAR/BAR contract is the last date signed and delivered, whereas the NABOR, the effective date is the last date set forth on the contract by either party. So in the NABOR world, if you, for example, send over an offer at 5 o'clock at night, and then the seller receives the offer, likes the offer, signs it at 8 o'clock at night, but doesn't send it back to the buyer until the next day, the contract was signed on the first day, and that's the effective date. So you could lose 1 day or more, depending on how long it takes the seller to get back, on knowing that you're in contract and knowing that you have to commence inspections. Whereas the FAR/BAR, if they held the contract till the next day because it was late at night, it wouldn't be effective until the next day. So you can't rely on the date signed. You have to look at the date delivered. Amy, that's correct. The delivery, it's not that it doesn't matter. If you never deliver it and nobody performs, then you wouldn't be in contract. But if you sign it and eventually deliver it, you're going to be in contract. Adam, how does communication have to be given that's been accepted? You have to return the contract. You know, the contracts have to be in writing. So be very careful about that as well. And then, of course, in the FAR/BAR contract, closing is defined as it happens when all funds and documents are received by the closing agent on the closing date at the time decided by the closing agent. Whereas NABOR, we just kind of assume it's on the closing date when the documents and the money is delivered to the escrow agent, to the closing agent. They declare it closed and they have until 11:59 p.m. So it's a little bit more amorphous in the NABOR contract. FAR/BAR is a little bit more defined, but there are also, you have to consider that there are customs and practices in your county, and that is going to have a huge impact on when closing is. One thing I will mention at this point, just because I'm thinking about it here, keys. I want to say this to every realtor. Keys need to be delivered into the closing. They're not delivered when the seller gets the money. They're delivered at the closing. Disbursement occurs after closing in both contracts. Patrick is asking, was the title company permitted to conduct a closing in a different county? Both contracts say that the closing shall occur in the county where the property is located. Tony, I will have to take a closer look at your situation. The Fort Myers Board of Realtors determined the transaction was closed before the closer actually closed. I'm not sure how the Board of Realtors gets involved in a transaction. I've never seen that. So you'll send me an email afterwards and we can talk about that. One thing, so the Consumer Financial Protection Bureau has rules about the CD and delivery and signing that have to be followed by the lender. Used to be 10 days in both contracts. Now the new FAR/BAR contract, you only get 7 days. Amy says, so funding doesn't occur to give keys to the buyer. Amy, we fund immediately after closing, but say the closing, say it's 5:30, 6 o'clock at night, and it's a Friday night, and we close the transaction, the buyer gets the keys, and the seller has two choices. They can wait for their wire on Monday, or they can come to my office and get a check. But we fund, we close, and we deliver the keys at closing. That's in the contract. Okay. Any more questions about offer and acceptance? Okay. Assignability. This is a fairly simple thing. The FAR/BAR has got check boxes for whether the contract may be assigned or may not be assigned, or may be assigned but not release the buyer from the contract. NABOR has the contract as freely assignable without release of liability of the vendee, the party that signed the contract originally, up to 15 days before closing. NABOR provides an assignment of contract form that you can use. Needs to be signed by the assignor and the assignee. It does not need to be signed by the seller. For FARBAR, you'll want to have your attorney draft a simple assignment. Okay. Moving right along, I don't see any questions. So the new FARBAR contract version 6 that y'all are going to get November 1st actually does something very interesting. If you check the first box for cash, it's going to say, this is a cash transaction with no financing contingency. That's it. Sammy, no, a seller cannot object to a NABOR assignment if it's 15 days prior to closing. So the new FARBAR contract is going to not even remotely suggest that you can do financing on a cash deal. Everyone wants to pay cash because it's a competitive market, but they want to take advantage of the low interest rates. So you're getting a lot of cash offers, and you're getting a lot of people that say, I know I'm paying cash, but I've got time, I want to get a loan. And that's very scary if they don't have the cash to close. NABOR has a checkbox for cash, just like FARBAR, but it contemplates financing, saying specifically, buyer will pay cash, but may obtain a loan. Unfortunately, if you get a loan, you don't get the 10-day CFPB window under the NABOR contract. And same with FARBAR, if you check the cash box, no 10-day or 7-day CFPB window, which means you must hit the closing date. If you miss the closing date, since time is of the essence, and we're to talk about time being of the essence in a little while, time being of the essence for closing on both contracts, miss the closing date, buyer loses their deposit. Okay. Method of payment, financing. If you are going to be financing the transaction, this is where it gets a little crazy. There's major differences between the contract and how financing works. We're going to walk through. Amy, you have a question? I see your hand up.
Yes, my question was when you went over the CSB EB 7-day extension versus the NABOR 10-day inspection, I didn't really understand.
Oh, okay. So let me back up real fast before I get into financing, because I want to make sure everybody understands this. So the Consumer Financial Protection Bureau requires that the CD be signed 3 days prior to closing, but there's a mailing rule that says that if the CD is delivered anything other than electronically, that you have 5 days for mailing. So you need to make sure that the CD gets signed prior to closing. And so the contract for when there is a financing contingency builds in extensions. And what I was saying about 7 versus 10 days in the FARBAR is they changed the contract. The current version 5 of the FARBAR contracts give a 10-day window. The new version 6 that comes out November 1st shortens that to 7 days. And the NABOR contract gives 10 days. So that's what I was talking about. Scott is asking, if both parties sign at 9 a.m. in the morning, the lender money doesn't come till 3 p.m. You give keys at signing? No, Scott. The keys don't go at signing, they go at closing. So just so everybody understands, generally on your typical finance deal, seller signs and buyer signs, money comes in, funding approval is received from the lender. I've got all the money, I've got all the documents. So then I close the transaction, risk of loss passes to the buyer gets the keys, and the seller gets their money. And it all kind of happens in order, you know. And if it's after 5 o'clock and the seller can't get their money because the wire rooms are closed, I can give them a check on the day of closing, or they can wait till the next business day and we can wire funds, whatever the seller wants. So hopefully that makes sense. Okay, any more questions about that stuff before I go into financing? Because the financing gets a little complicated. Okay, so FARBAR financing. There's been a bad case that many of you may have heard about, Florida Investment Group 100 LLC versus Lafont, the Lafont case. Pretty much is a Scud missile that's destroying the buyer if they don't get the right financing applied for. So complying with your financing in the FARBAR and really the NABOR contract as well, because the case can be applied to the NABOR contract. You've got to make sure that you apply for the financing stated in the contract. And I'll talk about that on the next slide. But just to walk through the differences, FARBAR default is a 30-day loan approval period. NABOR default is 45 days to secure financing. The appraisal is a part of the loan approval in the new FARBAR contract. So you have to get approved and you have to get the property appraised within the loan approval period. This is a major change to deal with that Lafont case. In the FARBAR contract, you have to provide diligent effort is now defined as providing all of the documents required and paying for them. Lisa, yes, you should add more than 30 days for FHA financing, yes. The diligent effort and good faith provisions of the NABOR contract are not clearly defined, but they're stated in there that you must have acted in good faith with diligent effort to get your loan. In the FARBAR contract, the buyer must terminate the contract in writing before the end of the loan approval period if they're not going to get approved. Under the NABOR contract, the buyer can't terminate until the financing contingency period ends, and then they either have to be approved, denied, or have acted in good faith to get the loan, but it's been neither approved or denied. And in the FARBAR contract, the seller then will get a 3-day right to terminate after the loan approval period if the buyer has not given their approval letter or terminated. In the NABOR contract, at the end of the finance contingency period, the seller can terminate, but the deposit goes back to the buyer. So you got to be very careful when you're deciding what you're going to do. And this is one area where the contracts get really different. And I will say my preference for a finance transaction, I think it's a much less harsh result to both parties. It's much more fair to both parties. I prefer the NABOR financing contingency. But I know a lot of folks in Lee County are not familiar with the NABOR contract. And so we're going to go through a few things on the FARBAR financing. First, though, I just want to show you some bullet points about the Lafont case. It's not a good case. The court awarded the deposit to the seller, and the lesson in the case is if you put financing in your contract, FARBAR or NABOR, apply for that loan. If you say it's going to be conventional, apply for conventional. If you say you're doing an FHA, apply for FHA. If it's going to be a 30-year fixed at less than 4%, apply for that. That was the issue in the case, was they changed their loan terms and they never got loan approval. And now the FARBAR version 6 that comes out November 1st is going to attempt to fix this, but I don't think so. Gene, no, you can't check all of them. Okay, let me walk you through the FARBAR financing, the new financing. And I want to say very much thank you to Jeff Jones, who prepared this slide, and I modified it for the new changes. First of all, loan approval period, including the appraisal, the buyer must be diligent and use good faith. The default is 30 days. That's your loan approval date. And the buyer must notify the seller they've been declined and they get their deposit back. Or they don't notify the seller gets 3 days to cancel. If they cancel, the buyer gets their deposit back. If the seller does not cancel or the buyer gets approved, the contract proceeds and the buyer's deposit goes hard. Then we look for property related conditions. Is the property approved? Like for example, for the condo association, did it pass the 4-point inspection? Can they get insurance? If there are property related conditions that cause a problem, contract ends and the buyer gets their deposit back. If there are not, we go to closing. So does everybody understand the finance? I know it's very confusing, but basically this is the FAR bar. NABOR is much simpler. It's 45 days by default. You get to go through, the buyer goes through the approval process with the lender. They come out at the 45th day and they say, we are approved or we are not approved. And then on the 46th day, the buyer can terminate if they're not approved, or the seller can terminate if the buyer doesn't waive the contingency in writing. Sammy is asking, what do you mean if the court strains itself to give the deposit back to the seller? Well, in that case, several lawyers in the committees that I serve on think the deposit should have gone to the buyer, that the court took a harsh approach to the definition of loan approval. They really pushed to get the deposit to the seller because the buyer didn't follow the strict terms of the contract. So that's what I meant by that. Amy, I'm sorry it was confusing. You're asking if the buyer is denied their loan, you lose. That's not correct. Amy, if the buyer is denied their loan and they terminate within the loan approval period, then they get their deposit back. Okay. Any more questions about financings? I know this is very difficult. Okay, we're going to move on.
Sam, so they can still amend the 30 days and change it to 45,
Yes,
right?
yes, Mark, that is correct. 30 days can be adjusted in the contract. Yes, that is just the default. Okay. Ali, yes, in most cases, we would want both parties to sign a termination and deposit release agreement so that the title company doesn't get in trouble. But I make those decisions on a case-by-case basis. If it's a clear case where the buyer has a right to the deposit back, I'll have the buyer sign a termination and indemnity with me, and then I'll give them their money back if the seller is being obstinate. I know some title companies won't do that, but I just don't think it's fair to hold the money or go through an interpleader action when it's a clear case. So as long as the buyer is willing to indemnify the title company, they get their money back right away. Other questions about financing? All right, let's talk about condos and HOAs. Mike, are lenders educated on the finance contingency? Tough question. Many of them, we have some very good lenders in the Southwest Florida area that know the contracts. Yes, Luann, we're recording. Heather, under the FAR contract, I don't think you need a proof of denial from the lender. Under the NABOR contract, you must show either proof of denial or that the lender is neither approved or denied after the period is over. And then COA is condo association.
Sam, I have a question.
Yes, Christine.
I belong to the Bonita Board of Realtors. I used to belong to NABOR. Now belonging to BEAR, I was told by NABOR that BEAR members are not authorized to use the NABOR contracts because the NABOR contracts are a benefit to NABOR members.
I believe that is the case. You have to check with the board on that, but NABOR puts out a set of contracts for NABOR members. So if you're not a member of NABOR, then you probably should not be using the NABOR contracts. I think that's a fair statement.
What would we do then when we're showing listings and the seller's agent says use NABOR contract only? How do, and I've tried to explain before what I've heard, I actually do have access to the NABOR contracts and I've just been using them anyway, but I just wanted to see what the legality of it is.
That is more of a question of copyright, which I have to admit, I do not know very much about. I would say that if you're not a member of NABOR, you should not be using the NABOR contracts. If the listing agent is insisting that a NABOR form be used, then talk to the listing agent about them providing the contract. If they're a member of NABOR, just be very careful about that, because I do know that NABOR is particular about its copyright on its documents. Okay, homeowner associations and condominium associations. So these contracts are very different in this regard. The FAR contract has addenda A and addenda B. Addendum A is for condos, addendum B is for homeowners associations, and they disclose approvals and rights of first refusals. All of the various association fees are disclosed on the addendum. And for condominiums, special assessments are negotiated with the default of the seller paying all before closing. NABOR, the required disclosures, the statutory disclosures are in the contract in the main form, so you don't need any addenda. You would just use an HOA disclosure, which is a statutorily provided form. That means that they just copy the language onto the paper right out of the statute. And by default in the NABOR contract, the seller pays all assessments due before the effective date, whereas in the FAR contract, it's before closing. So that's a major difference. If assessments are coming, this was a big deal in Irma when most of the special assessments from Irma have been assessed now. I think there's only a few that I've seen that are outstanding. Now in NABOR world, the seller pays for pending special assessments if not properly noticed up to 1% of the purchase price. And there's a big debate in NABOR as to what pending means. If two people are talking about an assessment by the pool, probably not pending. But if they're at a board meeting and they're talking about it and it makes it into the minutes, or it's at the annual meeting and the members vote on it, pending is much more likely and needs to be disclosed. Under NABOR, there are specific provisions that require the buyer to investigate and understand the community that they're about to buy in. Bundled golf comes up as an example. Some other disclosures that NABOR provides include, we call it community investigation, where the buyer is obligated to understand the property that they're buying in before they even sign the contract. And then of course the statutorily required disclosures, I said, that are in the contract already. Questions about condominiums and HOA differences? I will say that I think the FAR has a better regime in this regard because they allow for more variety, but they have to, obviously, because they go across the state. What NABOR does is it provides a worksheet, a non-binding, and we say it clearly on the form, it's not a binding thing, it's just an informational worksheet that you can use to disclose the various fees. For example, Vanderbilt Country Club, they had 7 or 8 fees you got to pay every year and every quarter. So disclosing all of those, or the Pelican Bay Foundation fee, that you can use the NABOR worksheet for that. Whereas in FAR, it's all on the addendum at the bottom of the addendum. Lisa, I am avoiding using lines because I'm using red lines, so my lines won't match your forms if you're just looking online or if you've got a set. So the line numbers are not going to work out, unfortunately, folks. Like I said, I'm using the red line versions in my presentation for the newest ones. What I will do is I will put all of these slides on a PDF and email them to everybody afterwards. Okay. Questions about the HOA? COA. Seeing none, let's see, make sure I've answered every questions in the chat. I don't understand the question about the appraisal. We'll come back to that. Okay. Title insurance, my favorite subject since I am a licensed title agent. Under the FAR, you pick who pays for title by checking a box, and the person who pays for title picks the agent. And the lien search, which is separate from the title search, I'll say that again, there's a lien search that is separate from the title search, follows the title insurance. And then title is due to the seller either 5 or 15 days before closing, depending on your financing provision. Now, in the NABOR contracts, the buyer picks the title agent regardless of who is paying for the owner's title policy. And there's no options. The seller pays in Lee and Charlotte, and the buyer pays in Collier. It's just written right into the pre-printed language. And the buyer always pays for the lien search. And the title commitment is due 10 days after the effective date. So that's a major difference, because you can have an extension and a cash deal in a FAR contract for title issues if the title insurance policy isn't delivered till 5 days prior to closing. So that's one thing you got to look out for in your FAR contracts. Make sure that title commitment gets delivered after the effective date, not prior to closing. That's a choice, so that you are not delaying your closing for title issues. Okay, questions about title? Seeing none, that's an easy one.
Can you repeat
Oh.
that last thing you said about the title being after the effective date? I'm sorry.
So you send your contract to your favorite title company, hopefully me, but not necessarily. Go to your favorite title company and they commence a title search. That title search takes 4, 5, 6 days. That title commitment is provided after the title search is complete. That's the Bible of the closing. It says what all the problems are on the title and what has to be taken care of. That's your sufficient funds affidavits for associations, your cleaning up open permits, open permits for contractors, paying off mortgages are on there, getting association approval letters on there. All that stuff's got to be put on the title commitment. And then in the NABOR contract, the buyer has 10 days to get that title commitment to the seller. In the FAR contract, depending on whether it's financed or not, let me just get that section pulled up so I say it correctly. At least 15 or 5 days, depending on, that's a blank, days prior to closing, the title commitment should be issued by a title agent and delivered to the seller. So the title commitment's got to be delivered, but if you only deliver it 5 days prior to closing, you run into a problem because you have the cure period to extend the closing date. That's the issue. You don't want to extend closing.
So I'm sorry. So for FAR, the wording is
Well, it's funny. I just
it's
noticed
before closing.
in the contract here, they changed it's 5 days prior to closing or 15 days prior to closing. But I would give yourself time in the FAR at least to get that title commitment done as quickly as possible.
Okay, and in NABOR, it's after the effective date. So one has the closing, before closing, and the other one has effective date.
Right.
Okay.
I have a question in regards to the buyer or the seller picking title.
Sure.
Let's say the buyer picks the title agent, but then the seller's agent says, my seller is using XYZ title.
So the buyer can go to a title company, of course, and they can have a title company or a lawyer do their closing when the buyer is paying for title. The seller can either use the buyer's title company or get their own attorney. Title companies can only do closings when they're issuing the title policy. And I know there's a lot of title companies in Southwest Florida that will just do a closing when they're not issuing title because they represent the other side that is technically the unlicensed practice of law, and the title company could get in trouble. I mean, I don't think anybody ever calls the bar on them, but that is technically a violation of the bar rules. So if you, for example, are in Lee County and the seller is paying for the title policy, because that's the customary default, then the buyer could either get their own attorney or use the seller's title company. But the buyer can't go to their own title company because that title company is not writing a title policy. Collier County, where typically the buyer pays for title, it's the opposite. The seller either gets their own attorney or goes to the buyer's title company. I know that gets confusing, and I'm sorry about that, but that's just the lawyers and title companies fighting over who's in charge.
So whoever is paying for the title policy is the one who is where it closes, and the other one is just a secondary?
It's the other side's representation. For example, if one of my competitors is has the buyer in Collier County is doing the closing, and the seller comes to me and says, Sam, I want you to represent me in the closing, I would prepare the deed, I would prepare the bill of sale, I would prepare the affidavits, and I would deliver those to the buyer's title company. And I would say, these are the seller's closing documents, please approve them. And then I would go and I would sit with my seller and explain the documents and have him sign the documents, and then I deliver them to the closing agent at closing. Andy, there's a number of affidavits that have to be signed. They're all for clearing title and making sure that the seller is a US citizen or the FERPTA issue. We have another question on the appraisal. I have a loan that says it will give a loan denial letter if the property does not appraise, but for full amount. Bob, I will have to come back to you on that one. I'm not sure I understand your question. Let's talk offline about that. Okay, Danielle, in the NABOR contract, are you speaking about standard B? It looks like it's 10 days for seller to provide title insurance and 30 days for buyer to evaluate. Danielle, where are we at here? So Danielle, I see what you're saying. Yes, the seller has 10 days to provide their prior policy, and the buyer has 30 days to evaluate. That's correct, although we don't usually use that 30-day evaluation period because it doesn't take that long anymore. But that's the prior policy that the seller is supposed to deliver to give us base title. Yvette, what are the pros and cons of the seller using the buyer's title in Collier? The pros are that the title is just done in one place. The cons are the seller may be asked to sign documents that they don't necessarily need to or want to sign. Those are that's the real pros and cons. If the seller is asked to sign, for example, a survey affidavit because the buyer doesn't want to get a survey. Well, if the seller hasn't been made aware of the fact that he's signing an affidavit swearing that there's been no changes, yet the seller has actually put in new air conditioning handlers or moved his fence or installed a pool, which I've seen all these cases, the seller needs to be aware they cannot sign a survey affidavit. They should communicate that to the buyer's agent, and the buyer needs to get their own survey. That's a big one where you can run into a lot of liability if the buyer's title company doesn't want to tell the seller, hey, you need to have your survey evaluated by an attorney.
Doesn't the buyer, like if the buyer picks the title company and then the seller chooses to go with that same title company, doesn't the title company represent both the buyer and the seller?
The title company doesn't represent anybody, but sometimes they represent the lender in finance transactions. Title companies don't have fiduciary obligations. They're not representatives.
Exactly, but they would both be customers, or
They would both
whatever,
be
equally the
customers.
same.
They would both be customers, but it's you lazier title companies where the survey is the big one that I think about, but there are other affidavits. A lot of the bigger title companies, I won't use names, but the large giant national corporation title companies, they will ask sellers to sign indemnity agreements that are not required. That happens in every transaction. So if you go to giant national title company, You're going to see your seller signing a bunch of liability documents that he doesn't have to sign, that he didn't contract to sign. And if he was represented by me, I would tell him not to sign. So that can be a major issue.
Do you recommend that the buyer and seller use different title companies?
Yes. Yes.
Perfect.
Ally is asking, can the transaction still proceed if the seller does not sign buyer's title? Ally, I'm not sure what you mean, but the transaction would proceed based on the contract regardless. Okay, let's move on to inspections.
Here,
So-
sorry, can I just clarify what you were just talking about? If they make the seller sign indemnity agreements, they
Yeah.
say no, they can, the
The
seller can the
transaction
title
would still
company
proceed,
help.
yes. The transaction would still proceed because the title company has no authority to force the seller to sign something they didn't agree to sign.
Okay,
If the title company wouldn't proceed, then you would need to go to a different title company or hire an attorney.
okay, thank you.
Yep. Okay, inspections. So inspections are a big difference between the contracts. Let me pull up my inspection section. So under the FAR contract, you get three main inspections. You get the general, the wood destroying organism, and the permit inspection. And there is an addenda that you can attach for mold and lead. Now, the FAR contract, the main contract, has a provision that locks the seller into spending money in section 9 up to 1.5% of the purchase price is the default. It can be changed when you have the seller. I suggest that you change it to a dollar amount so that the seller knows their liability specifically. And I think 1.5% can be a lot of money on $1 million transaction, $45,000, you know, 15 for general, 15 for WDO, and 15 for permits. If the repairs exceed the limit, then the seller gives notice and then either party may terminate. And then of course, in the FAR as is, it's a free look. Now, NABOR is very different. You get 6 inspections. You get your systems and equipment, that's your air conditioning, your roof, your structural. You get a radon, you get your lead-based paint, your wood-destroying organisms, your mold, and your open permits, all in the default contract. So the seller is limited, if you choose remedial action under the NABOR contract, to the fair market value of the items in working condition. And there's a regime in NABOR, the 15, 5, 10, 5 days for the inspection process. Typically in the FAR and the NABOR, you get 15 days to do your inspections. And then in the NABOR contract, the buyer gets 5 additional days to review their reports and deliver them to the seller. Then the seller gets 10 days to evaluate those reports and respond to the specific inspection election where the buyer can choose either to receive a credit to have the seller make remedial action or some combination of those two. And then of course, if the seller has the right to reject the remedial action or the credit or the combination, and then if they reject or counter the buyer's election, which we assume is proper under the contract, although it often never is, it rarely ever is, then the buyer would have 5 days to terminate. And of course, the NABOR as is a free look. And I've got a couple of slides on inspections.
What do you mean as a free look?
A free look is, and I'll read the language to you so that you, it's basically the buyer can go in, look at the property, conduct inspections or not conduct inspections, and make the decision. Where is the free look?
Basically, it's
Let me read this to you and then I'll explain it. Buyer shall have 15 days after the effective date within which to have such inspections of the property performed as buyer shall desire during the inspection period. If buyer determines in buyer's sole discretion that the property is not acceptable to buyer, buyer may terminate this contract by delivering written notice of such election of the seller prior to the expiration of inspection period. What that means is, and I read the FAR, the NABOR is very similar. What that means is you can conduct inspections. You don't have to conduct inspections. You can walk around the property. You don't even have to go to the property, but within 15 days, the seller, the buyer notifies the seller, I don't want the property, and I don't have to give you a reason why I don't want the property, and they can walk away and get their deposit back. It's a free look. And actually, I hesitate, Lisa, that is page 6 of the red line that I'm looking at. I hesitate to say this out loud, but it's kind of true. If you've got financing in the FAR contract and it's a 30-day loan approval period, it's almost like having an as-is contract, because there's no provisions for why the buyer, for the buyer to state why they terminated under the financing contingency, other than they've exercised good faith and diligence. So it's a weird situation in the world of financing these transactions and the FAR contract, where you can actually get a much longer free look. And I can explain that separately. But going back to inspections, they are different in the way they treat specific items. FAR says that torn screens, fogged windows, missing roof tiles or shingles are to be repaired. NABOR says they're cosmetic. FAR contains a procedure for disputing inspections with dueling inspectors, dueling experts. The buyer's inspector and the seller's inspector get together, pick a third inspector who determines if something is a defective item under the FAR contract. There's no procedure in NABOR during that 10-day review period where the seller is looking at the buyer's reports and making a decision about whether they want to proceed. There can be some back and forth as to what is actually a defective item, and then you can make a revise. You would ask the buyer to revise their inspection election, or you would come up with some other agreement. Okay, and then open permits. The FAR provides a 10-day extension for final inspection of open permits, but in the NABOR contract, you have until up to 5 days before closing to find them, but there's no extension of closing. Amy is asking, does this mean they need to fix these on the FAR? What do you mean, Amy?
I see that it says torn screen, fogged windows, all that stuff, missing roof tiles.
Has to be
shingles.
repaired, yes. The seller has to fix those, yes. Okay, I want to talk about permits for a second because they're kind of a pain, especially in Collier County, really throughout the state because everybody's so backed up. I put some bullet points up here just for your review, and you can have them when I email the slides afterwards. But the short of it is, in the NABOR contract, we changed it last year so that the deadlines for conducting inspections are moved so that the buyer, as long as the buyer conducts their permit search within 5 days of contracting, if they don't get a response back from the county, they have up to 5 days before, make sure I say this correctly. It's up to 5 days after buyer receives the permit search back from the county or from the person that conducted the search if you use a service. And then the seller gets 10 days to respond, and you follow the standard D2 for remedial action versus credits. And closing is not extended regardless of anything that you find in the permit search under the NABOR contract. Whereas under the FAR contract, you go through, you do your inspection. Get my note on this one. There's a whole provision for the closeout of the building permits that includes up to a 10-day inspection or 10-day extension for permit inspections. questions about open permits? Okay,
Yes.
oh, so go ahead.
It says that the buyer or the representative of the buyer. So if you are the title officer, I thought one of the things was you do the title search anyway, right away.
You do the
I mean,
title
the-
search, but remember, open permits are not part of the title.
Right, but you can request, a buyer can request if they are using an attorney to do the permit search as well, since
Absolutely.
they are so back-ended, backloaded. Are they getting done within 10 days or 5 days, or it's just a hypothetical number?
So Tina, so what
yeah.
we do is the buyer comes to me, hopefully within 5 days of the effective date.
Right,
I immediately order a lien search through the lien
Right.
search provider company. We use Property Net Research in my office. PropLogix is another one. We order those searches.
yeah,
They then go to the county and they look up open permits with the county. As long as
Right.
we've ordered that search within 5 days, we're in compliance.
it's
with the
okay,
contract.
okay, all right.
Yep.
Thank you.
I have a question.
Yes,
If,
Sylvia.
if it's an as-is contract and the seller who I represent did not get a permit for their air conditioning, it was done by a good company. And it does not, if it does not, I have, so I'm submitting a permit request and it does not get done before closing. How does that affect the contract?
Well, the operative words there, Sylvia, are as is contract. Under both as is contracts, FARBAR and NABOR, the seller is not obligated to make repairs. So what you need to do is during the inspection period, are you on a FARBAR or NABOR form?
NABOR, 9
So,
days.
Actually, I'd say it doesn't matter. What you need to do is you need to have an amendment to the contract drafted that says seller will correct the open permits. They will close and final the open permits within so many days after closing and escrow money to ensure performance and make sure that permit inspections are taken care of and any monies owed for the permits are paid. So you would on an as-is contract, you would do a separate amendment. That make sense?
Yes.
Okay. Michael Work is asking, is this addressing uncooperative management companies for responding to an HOA or condo doc request? Mike, no, this is for permits. Condo doc requests, of course, are covered by statute. Let's see here. I'm getting a lot, sorry, it's moving on me. People are typing. So if you have an uncooperative management company, you need to get the attorney. You need to get an attorney. They need to write a letter because it's statutorily, there are statutory deadlines for these management companies to respond. They don't like it, but if they want to get a fee for their work, they better comply with the deadlines. If they don't comply with the deadlines, they still have to produce the estoppel or the docs, but they don't get paid. That's the penalty.
I have a
Amy.
question, sir.
Go ahead, Mona.
This is Mona. One of your slide, as I understand it now about inspection, it looks like it doesn't matter what contract it is, as is or regular contract, the NABOR or FARBAR. Looks like within 15 days, the buyer can walk away?
No. On the as-is contract for both FARBAR and NABOR, the buyer can walk on the as-is. On the regular contracts, the buyer cannot walk under either contract. They have to go through the inspection process. Does that make sense?
Yeah, that's what I knew before, but your slide, it shows like, what is it? You called it free something,
That's a free look for the as-is.
right?
Yeah, on the as-is,
Oh,
on the as-is, you can walk.
Oh,
Okay.
thank you.
Here. Yep. Okay, I'm getting a lot of comments here. Let's see. Ally, I do not know if all counties mandate permits for AC units. I want to say yes, but I'm not certain. Pam is asking if a roof is being replaced on a condo prior to closing, is an open permit permitted so you can close? So Pam, that's a great question. If the condo is replacing a roof, the condominium roof in 99.9% of the cases, unless you are in the third floor unit of a 3-story building and you've got special provisions in your condo docs, the roof is not part of the unit, the condo that you're selling. So condo roof replacements are not something that the seller has to deal with in the NABOR or FARBAR contracts. Andy is asking, my seller of duplexes with enclosed porches in Lee County, which they bought it. They said they do not require permits since there are closures there already. Is that true? I hate to ask the county, get my sellers in trouble. Andy, if there are enclosed porches that look like they were added later, they have to be permitted. And if they're not, they've got to be fixed. And that I know you don't want to get your seller in trouble, but I'll say this to all the realtors on the call. Remember, Johnson v. Davis is lurking in every transaction. If you know of an unpermitted improvement and it's material and materially affects the value of the property, you've got to disclose it, even if your seller tells you not to. Yvette, how involved do you personally get when representing Collier County buyer or seller as it relates to issues involving permits, title inspections? Your answer might be different for each. Yvette, I get involved. So my office, I have paralegals and closers and processors that move the paperwork through, and they bring issues to my attention. And of course, the realtors bring up the inspection items to my attention, and I get involved. I do what I got to do to get the permits closed, or to deal with the inspection item, or to do the escrow, whatever it takes. I am there and involved in every transaction. And there's a lot of them. Okay.
Sam, on the FARBAR contract, in regards to inspections, it says that the buyer notifies seller within the inspection period. So often these days, the seller's agent pushes you to do a smaller inspection period so that you can potentially win the contract. You know, instead of a 10-day or 15-day, they want a 5-day or 7-day. How do we get a permit search within and back within that inspection period?
You don't.
Exactly.
You run the risk of closing with an open permit. And that's a major problem. And that happens a lot. I will counsel my buyers. I'm like, hey, you agreed to a 7-day inspection period. I'm not going to know if you have open permits during your as is. I'm sorry. It goes too fast.
And what's the typical, would you say, time frame to get the open permit?
To get back from the county, if we press and we hustle and we get lucky, it's still going to be 10 to 15 days.
Can we put that as like an addendum or something that says that?
Yep, and that's what we tried to do in the NABOR contract, but by default is give you additional time to get your permit searches done.
And that should just be on a separate addendum for the FARBAR?
Either in the other terms and conditions, some language along the lines of buyers shall have up to 5 days prior to closing to advise seller of open permits, and seller agrees to close open permits and escrow money. I mean, we'll have to customize it for each deal, but yes, I would suggest that if you are a buyer and you're getting pressed to do a 7-day inspection on an as-is contract, that you do something about the open permit election. Danielle asked a really good question that relates to this. So Collier County has 2 portals that are, Danielle, I'm going to say they're pretty reliable. They're not 100%, but they're pretty reliable for code enforcement and for open permits and for Lee County is not so much. But in Collier County, the City View and the old permit portal are pretty good sources of information. They will give you a base case. The nice thing is if you go through a PropLogix or PDR, property research company, you get a certified search, then you can sue somebody if they're wrong. If you do it yourself, if you're the realtor and you do it, which I never recommend a realtor do a permit search, then you get sued as opposed to the other company. So it's a matter of liability. Other questions about permits? I know it's a big deal. I know we get a lot of them. Yvette is asking, yes, I get involved. I talk to the buyer and the seller, and I make sure they understand their contractual obligations. Yes, I do, Yvette.
Hey, Sam, Mark Scalari here. How are you?
Good, Mark.
Quick question is, as a listing agent, is it a good practice to search the portal anyway before you list the property when you're working with, to make sure, because a lot of times the sellers don't know that something didn't close.
Right. And a lot of times, especially if the seller bought before 2014 in Collier County, when NABOR made the deal with the county and started doing all this permit stuff, they may have purchased, never even done a permit search. And these permits, I mean, we find permits from the 70s in some of these things. And so if I'm the listing agent, I'm going on the portal just to do a cursory review. And I'm going to tell my seller, hey, listen, you have 3 open permits. Why don't we get these wrapped up before we even go to contract so you don't have to deal with them? Because they're going to come up in the inspection. And most sellers will go, okay, that makes sense. And they don't know about them and they're frustrated, but they get it done. But yeah, we deal with that a lot.
Thanks.
All right, we are bumping up against a time here. I don't want to keep you guys too long. Lisa, yes, I can do this again after November 1st. Let's get through force majeure. So FARBAR has a force majeure clause. NABOR does not. FARBAR has defined terms that if you cannot, with reasonable diligence, overcome the pandemic, overcome the hurricane, overcome the fire, then you have up to you close 7 days after the force majeure event passes with a maximum extension of 30 days. Note that the new contract that I'm referring to in this presentation, FARBAR version 6, actually specifically includes pandemics, but don't get all excited like now you've got another out, because it's with reasonable diligence. And as a result of the pandemic, we now have remote online notaries been beefed up. We have DocuSign, we have Zoom, all this technology to get us through the pandemic. And it's reasonable diligence is the standard to overcome the force majeure. So I wouldn't expect that you're going to be able to come in and say, oh, there's a pandemic, I don't have to close because I've got it's 7 days after the pandemic ends. So don't plan on that. I've already had that argument made to me. It doesn't work. NABOR, no force majeure clause. The seller bears the risk of a casualty. That casualty is defined in the contract as fire, flood, extreme weather condition, or other casualty. Typically, we're talking about hurricanes, what we're thinking about. The buyer can delay closing after the casualty if they can't get insurance at a reasonable rate. That's the box. When we're in the cone or the box, whatever it's called, the news is saying there's a hurricane headed our way and you can't get insurance. We close 5 days after coverage becomes available with a maximum extension up to 30 days. And then after the casualty event, if the buyer cannot get insurance, and I did have this case after Irma where a window was blown out in a condo and the condo got destroyed. If the property is uninsurable, the buyer can terminate. Okay. Time of the essence. This is so important. I want everyone to understand this. In FARBAR, time is of the essence for every single deadline. You can't miss your deposit. You can't miss your second deposit. You've got to do everything on time or you lose all of your deposits, which I will talk about on the next slide. Under NABOR, time is only of the essence for closing. So if it's Friday and you sign a contract and you do a 3-day initial deposit and then it rolls to Monday and the buyer is not organized, they got to sell stock to make the deposit, it's going to be 2 more days. That's fine under the NABOR contract, except there's this case out there that got presented to me called the Chuchi versus Pickett that says the deposits are so important that you shouldn't miss the deadline. So you may have a notice about default and opportunity to cure for non-closing deadlines under NABOR, but just know there's some case law out there that says you may not. So you should try to make every deadline. The other thing I'll say is on your inspections, where you miss an inspection deadline, particularly under the NABOR contract, which has defined penalties for missing deadlines, time is of the essence. So if you need 16 days on a 15-day inspection period, you're going to lose your inspections because it's time may not be of the essence for that date, but there's a consequence of missing the deadline. You don't get an opportunity to cure. Does everybody understand that? You can't miss deadlines in the contract. That's pretty basic. Okay, almost done. Default and dispute resolution. Sammy, no, the seller does not have to be reasonable in when time is of the essence. The seller can say, no, you missed the deadline, we're done. Give me the deposit. They can absolutely do that especially in a FAR contract.
What is it? Can you please explain the difference between the FAR, the NABOR, regarding calendar days, Saturday, Sundays?
Okay, so they both pretty much do the same. Although in the new contract, they change it to, where is it? You roll on if the deadline falls on a Saturday, Sunday, or legal holiday, as that's defined under federal law, which is the federal holidays, you know, the 11 or 12 holidays you get under federal law. If the deadline falls on that date, it rolls until the next business day. Where is it in here?
That's FAR?
Under both of them.
Oh, okay.
Although on the new contract, I just noticed, I didn't even notice this before, they crossed out the 5 p.m. So it used to be under FAR, you had until 5 p.m. on the next business day. It looks like it now goes through the full day. I will confirm that with everybody. Under the NABOR contract, make sure I say this correctly. Except as otherwise expressly provided by law, if the closing date, any deadline or the last day of any time period falls on a Saturday, Sunday, or federal legal holiday, said deadline shall be extended to the following business day. That's 11/59, because the contract also says the deadlines expire at 11/59 in the NABOR contract. It's not explicit in the FAR contract. Does that make sense? We good?
Yes, thank you.
Okay. Default and dispute resolution. This is the last topic I've got to talk about today. Then we'll take open questions. FAR, all deposits, that's deposits, not made or not or pending. All deposits go to the seller if the buyer defaults. Under the NABOR contract, if the buyer, for example, makes the first deposit but doesn't make the second deposit because they changed their mind, the seller's only remedy is the deposits made. It's very specific. If buyer does not perform buyer's obligations hereunder, all deposits made shall be paid to seller as liquidated damages, which shall be seller's exclusive remedy. That's the NABOR contract language. So big difference in the lawsuit that you're going to have under FAR versus NABOR. FAR also has a mandatory mediation provision if the parties don't settle after 10 days. And then if both contracts have a prevailing party attorney fee provision, which means that the winner of the lawsuit gets their attorney's fees paid. I will tell you, I have now been doing this exclusively since 2007. I always have to remember when my daughter was born, 2007. And I've seen many deposit disputes. I've never seen one go the distance. So be very careful about that, although it has happened and there are cases out there. All right, questions about default and dispute resolution? Okay, any general questions? Shout them out, put them in the chat. Questions about the differences in the contract? Is everybody good?
Can you repeat everything you just said?
Sure, Ally. Starting over on slide 1. No. All right, if there are no additional questions, Terry, I'm going to email a PDF of the slides and a link to the YouTube video to everybody as soon as we get this copied over. So it'll be a few hours. I'll get it out to everybody. Thank you all very much. I really appreciate you taking the time today. If you have any questions, you call me anytime for anything. I really, really love taking questions from realtors. And the lead time, Sammy, is 10 minutes. It's pretty fast.
Thank you, Sam.
Oh, wait, hold on. I'm getting some thank yous and some substantive questions. Danielle,
Thank you so much.
Please go back over the title commitment due to seller in 10 days effective date. Where is that in the NABOR contract? Danielle, that in the NABOR contract, let's tell you real fast because everybody wants to jump off, is standard B. All righty, thank you, everybody. We're way over time. I don't want to waste any other people's time. Thank you very much.
Thank you, Sam.
Thanks, Sam. Tommy here.
And we will, hi, Tom. We will see you all in the next presentation. Thank you.
Thank you, Sam.